When I first passed the bar exam, I was appointed by one of the criminal district judges there in Texas to defend an individual who had been accused of burglary. I'm not sure who was more frightened, my client or me, when it came time to make a plea on his behalf. I was, of course, reinforced in my defense of this individual by the appointment of another more experienced counsel who made certain that he did get a good representation. And I'm very proud to say that we got a jury verdict of not guilty after we tried the case. But it also embedded in my mind the frailties we have in this criminal justice process, where we have to give competent counsel to each individual, whether it be a death penalty case or it be a robbery or some simple assault. It's important that our system operate properly, and it should not be a sham. It should not be, well, we've got all the forms here, you fill out the forms, but justice doesn't always follow the form. People ask me, are you opposed to the death penalty? I say there are, I presume, proper cases where the death penalty would be appropriate, but it's wholly inappropriate in every case in which someone is denied their constitutional protections. And there's no excuse in this country today for the possibility of the execution of an innocent person. That should be eliminated. Until we can reach that standard, then we should pause this procedure and get it right. We're not right in Texas. We can make changes that will get it right, and therefore avoid the prospect, the very real prospect, of the execution of an innocent person. I was the first lawyer since, I guess, John Connally to be an attorney as well as governor, and I was concerned about the procedures that we knew were sometimes frail at best. Texas had always had appointed a counsel to defend the indigent back way before Gideon versus Wainwright, and as a result, we had those at least apparent protections available for defendants, particularly in capital cases. However, the quality of that defense is another question that I think is of great concern, was to me, and to see if they were alert, they didn't sleep during the case or during the trial, and to make certain that they were taking care to raise the proper issues so that they could appeal the case if necessary. As governor, I had my counsel go through those cases individually and in great detail. I'd get a report from Leslie Benitez, who was my counsel, and she would give me her views of what the status of the case was and how good the defense counsel was, if it was credible, and if it appeared that they had adequate resources to defend the case. I then would go over and sometimes spend many hours going over detail by detail in the record of the case in order to make an independent determination that in fact this person had all of the constitutional protections that are set aside for capital cases. And I was persuaded in the time that I was in office that was true, and that they had not been abused in any way. Of course, times have changed, and since that time we've discovered, for instance, in the forensics world, as far as arson's concerned, we now have pretty strong evidence, overwhelming evidence, that the old standards that we used to determine whether arson had been committed or not are really nothing more than just imaginary standards. We have to go back now, I think, and review the cases that have been not non-capital cases where we have people on or have been convicted for arson under false standards. And I think that will hopefully happen quickly. Other states have similar problems. Texas needs to have better forensics laboratories. They probably should be independent of the prosecutors or the police in the state, and make them truly scientific laboratories to produce facts that we can then make determinations of whether they should proceed to enforce the law against this person or another person. We're way behind in Texas and other parts of the country as well, on bringing DNA evidence promptly to the attention of the authorities so that they can make determinations of do we suspect this person or someone else, and let DNA be an effective tool to either prove guilt or innocence. I think that the foundation of our society is based on the rule of law, and the fact that we cast suspicion or we cast contempt upon the criminal justice process, we've taken steps toward the destruction and certainly the dissolution of our confidence in government. Reform, particularly in criminal justice areas, sometimes is the last thing the legislature wants to deal with. But when they also look at the extremely high cost of incarceration, I think we have some hope that we'll see diversionary programs that will be more effective in preventing a recurrence of the criminal activity, and also to cut down the cost, give better drug rehabilitation, drug programs to get people back in a life that's credible and that they are productive. That will cut cost. The legislatures around the country will be interested in that. As far as the criminal justice system's concerned on capital punishment, we oftentimes have to wait till the federal courts enter an order before we do the right thing. Hopefully Texas will be recognizing that we've made errors, that we've seen procedures that didn't work, we've seen forensic science that's outdated, both of which yield consequences of death upon the execution of a capital offender, and we just can't let that continue.